We are live.
Welcome, folks. This is House Corrections and Institutions. It is Tuesday, January 27th. It's our afternoon meeting. We're starting the afternoon with our legislative counsel, John Gray, to walk us through a new draft point one, House Bill 50, which deals with BGS doing an inventory of their own state-owned buildings and land to see if any of that could be used for housing. So John, it's all yours, and there's a new draft.
Very exciting. John Gray, Office of Legislative Counsel.
Maybe for you.
Here we are.
Keep it simple.
H50. I think this is going to look awfully familiar. Just going to be some slight presentation differences. We had talked about the session law pieces the last time I was in here speaking on this. But just to run through the draft, what you're going to see in section 1 is your updates to the inventorying section, and this is going to look a lot like what passed the House. So on line 12, subsection E, the commissioner shall maintain an inventory of all state-owned buildings and land and shall annually compile and update the information. That's in fact the change against what passed the House, is that update to annually. But this is just referencing state-owned buildings and land. No reference to state leased, as we talked about. So inventorying under subsection E, commissioner to maintain an inventory of all state-owned buildings and land and shall annually compile and update that information. And it's picking up what's under subsection G. So under subsection G, this should all be familiar. The head of each agency to prepare and forward to the commissioner annually in a format prescribed by the commissioner that inventory. And the final line, which is kind of the key substantive line of that subsection on page 2, lines 5 through 7, the head of each agency shall additionally indicate in its inventory in a format prescribed by the commissioner whether any building is vacant and whether any land is unnecessary for state purposes, which is the language that was used as passed the House. You'll recall that the Senate proposal of amendment had updated that state purposes to statutory purpose of an agency. So this is just returning to the House version of this, and to address the obvious question, what about all the housing pieces? Those are dealt with in the session law provisions, which we'll come to in just a second. These are your updates permanently to ongoing statutory obligations under Title 29. So as part of that inventory, the head of each agency would describe whether any building is vacant and whether any land is unnecessary for state purposes. That's your ongoing permanent obligation for the heads of those agencies. And as you can see, starting on line 9, at the start of each new legislative biennium, the commissioner would submit that inventory to the committees of jurisdiction. The real change you're going to see, although the substance is still the same, is for section 2, which starts on line 13. Previously, the language that you had seen here was built into that subsection G above and was creating a permanent obligation to yearly describe the availability for conversion to affordable housing of vacant properties. But now what you have is a time-limited duration requirement. So in each inventory that the head of an agency conducts pursuant to that subsection G through calendar year 2030, and I'll come back to that in just a second, the head of the agency shall identify whether any property is underutilized, suitable for conversion into housing, and then we have a long list of inclusive items. As we talked about last time, this language is drawn largely from the executive order with some slight cleanup. And then the practical provisions that we had for addressing, well, what if more information is required? Instead of having as an outright requirement in each of those inventories, when requested, this is starting on line 19, when requested by the commissioner of BGS, the head of an agency with the assistance of DHCD, Department of Housing and Community Development, shall provide an assessment of a property's infrastructure capacity and suitability for affordable housing development and a recommendation for use of the property to support meeting Vermont's housing production goals. So this is basically converting the executive order, which pulled the language from the initial H50 concept, into a time-limited requirement for the heads of agencies in the inventory that they prepare for BGS to identify whether property is underutilized and suitable for affordable housing, suitable for conversion into housing. Sorry, I keep saying affordable. And then upon request, making an assessment with the assistance of a party equipped to make this determination, the Department of Housing and Community Development, whether it has sufficient infrastructure capacity and could be suited for affordable housing development, and recommendations for use of the property to support meeting Vermont's housing production goals. There's one last thing I wanted to say on this piece, which is the time limited duration. We talked about a 5-year requirement. This is drafted using calendar year formation. So in some sense, you could say whether you get 5 out of this depends on the point at which this bill passes. If it passed today, my understanding is that the inventorying process in the spring, the heads of each agencies would then need to comply with this, and that would flow through to the summer report that BGS prepares, in which case you would get 5 instances, 26, 27, 28, 29, 30. But if it passes later, just a little bit later, right, and let's say the agencies have already prepared their inventories, then you may not get the full 5 count. So there's different ways to do this. One is just to time it based on when you expect passage to occur if you do. Another is to switch to a fiscal year concept. So then I think you would still need to specify, are we doing this for fiscal years 27 through 31? And then you might not get the update this upcoming year for the inventories that are being prepared, 2-3 months from now, right? So another way you could do it is in each inventory that the head of an agency prepares for the next 5 years, and just make it prospective next 5 years. Don't spell out what the years are. So there's different ways to think about it, is my point. And I think if it passed today, this would suffice, but I just want to raise the timing.
You really need to clarify the starting point, because there's been other issues in the past where there could be 2 different departments and they have 2 different interpretations of the starting date. So I want to be real clear when it starts.
Yeah, you could say in each inventory that the head of an agency conducts pursuant to such and such statute for purposes of the inventory being compiled in each of summers 2026. There's ways to make sure that you pick it up. It's how immediately do you pick it up? But yeah, just something to think about. But, yeah.
Yeah, I just want some real clarity if we go down this route as to when the clock starts ticking. So I've been exposed to other interpretations on other issues, that there's conflict, a different interpretation of when the clock starts ticking. So I want to be clear. The other thing, so this piece, if you look on page 2, lines 18, 19, that is drawn from the governor's executive order.
Yep.
And this was conversion into housing in general. So if you're going to look into affordable housing specifically, it has to be requested by the commissioner of BGS.
That's right.
The head of an agency. What do you mean by the head of an agency?
Sorry, the structure for that sentence is upon request by the commissioner, pause, the head of the agency shall provide an assessment. So the head of the agency is the one identifying those underutilized properties, right? That's the person compiling the inventory that goes up to BGS. So this
it could be any agency.
Any
It could be A&R, could be AHS. So it'd be the head of that agency, which is the secretary.
And in this case, they'd be able to call when they get this request from the commissioner. Let's say they've provided and they've said, we think this is underutilized, might be suitable for conversion into housing, but what do we know? We're not housing folks. If the commissioner comes back and asks, the head of that agency then says they can call upon the assistance of DHCD, at least as proposed here, and develop more useful metrics, which you see on page 3, an assessment of that infrastructural capacity and suitability for affordable housing development, plus recommendations for use of the properties.
So it's 2 categories for this second piece. It's affordable housing, and it's also housing in general.
Yeah, the general thing you would get as a yearly required component of section 2 is an identification of underutilized properties that are suitable for conversion into housing. Doesn't matter if affordable or not. And then if there's a request for greater detail from the commissioner, the head of that agency could call upon DHCD to assist them in these more specific informational requests. infrastructure capacity, suitability for affordable housing. I mean, and presumably commissioner could also ask, for other things if they want.
So that more specific request, was that in the governor's executive order?
No, so this was I would call this the practical compromise between trying to have a yearly process and what the executive order proposed. The executive order was a one-time requirement, and it leveraged the assistance of ACCD and DHCD to help in identifying conversion for housing. But because you're proposing, and part of this is my thing, because you're proposing just a yearly required update to the inventory, kind of strikes a balance between initial proposal in the first instances of H50, or for the heads of agencies to identify if something could be suitably converted to housing. But do they have the expertise to really know? I don't know. And so this is saying, we're going to give you an annual component, do that identification if suitable for conversion into housing. And then if it looks like there's something promising there, the commissioner can reach out, and the head would then, upon that request, avail themselves of the assistance of someone with expertise in this space to then supply greater information. So the formulation of this directive is not the same as in the executive order. The executive order is an outright request that you provide information on whether the housing, the underutilized property would be suitable for conversion into housing. But because this is just updating the inventory process, try to strike the balance between what they could reasonably do on a yearly basis, and then could they provide additional information that might be helpful.
The executive order, which is focused on housing, wasn't focused on affordable housing. And then we've kind of extended that to the affordable housing because it could be requested from.
I mean, you could also strike the affordable on page 3 if you just want it to align with.
I thought we talked about that,
Yeah,
getting rid of the word affordable.
Yeah, that may be my misunderstanding. I struck it from the first piece, which was the yearly inventorying. It used to say, shall identify for suitable for conversion into affordable housing. So I struck that. I think I misunderstood that it was a broader.
I agree with Connor. I think it should just be housing, because it could end up being higher end housing. It could be lower end housing. It's housing. They're not there to make that decision. They're there to find out if it can be made into housing.
I see it being an obstacle potentially if we
Correct.
keep affordable housing.
Yeah.
And that word is so
Voted.
yeah, and it doesn't really mean a whole lot right now.
And I'll tell you, I wonder if we do that, if it's needed on line 19, page 2, the sentence starting when requested. Because this is talking about sort of internal process for the administration. To me, the purpose of the bill is to get that first part in front of the legislature, and the legislature can make an assessment from there, what's underutilized and vacant. So, I mean,
Are you saying you get rid?
I think I'd be fine striking from 19 to
the end on page 3.
May I offer
Yeah.
what I think maybe some of the connection here is unclear. You would receive that information. Because what this section 2 is doing, the lead-in language is doing a lot of work here. In each inventory that the head of the agency conducts, get this information. If we scroll back up on page 2, line 9, on or before January 15th of each new legislative biennium, commissioners shall submit the inventory maintained under subsection E. So that information would be compiled into the inventories that the legislature receives. So this is not cutting out the legislature. We just don't need to specify them because, yeah.
Okay.
But you could still cut 19 through, you could cut the remainder of that if all you're trying to get is you will escape some administrative objections to this bill if you cut that line, because you will no longer have the request to have DHCD jump in and provide assistance to anyone, right? So.
yeah, well, that's sure it's a committee bill, but I'd be fine with that because, the commissioner wants it, they're going to request it anyways. I don't think we have to prescribe that, and we would get that information anyways. So I think it might overcomplicate it a little bit, where this is just mirroring the executive order and saying, okay, what they get, we get, and we get it for 5 years, or whatever we come up with there.
So just to be clear, so everyone's on board, what Connor's recommending on the bottom of page 2, line 19, that starts when requested by the commissioner, to delete all of that and go to the top of page 3 and delete everything on lines 1 through 3.
That's good with you, which you're the catalyst of the bill. That's good with me.
Or other folks,
Yeah.
I appreciate that, Vice Chair.
Yeah.
other folks, okay.
So the assessment part of it, that's covered somewhere else. For line 1, top of the 3rd page, shall provide an assessment.
of the
That's okay to cut out of there?
Structure capacity.
And I'm okay if it is, but I'm just.
I think it is because the assessment's already being sort of made in the first part too. Because the agency's identifying whether the property's underutilized and suitable for a conversion into, so there's an assessment at that point,
Okay,
right?
and that's all, that's what,
It also-
that's all. I just didn't want to cut that out.
I
It
feel like John
also
wants to
kind of
answer this
highlights.
question.
Okay.
I mean, I have an answer, but I didn't want to speak on your behalf. I think your point was, you're going to get this basic assessment, whether suitable for conversion. You may not get something like infrastructural capacity and the like, but you were making the point that in the political process, once it's been identified what properties are underutilized and would be suitable conversion, the commissioner would naturally ask for that information, which would be available to the legislative process. So it's kind of a point that you don't necessarily have to request it. It's here you're building it into an inventorying process, but there's other ways to receive that information. So if you think that the kick-in is sufficient, that there's going to be a yearly identification of whether property should be available for conversion into housing, that may be enough.
That's the assessment part of it.
Yeah.
Okay, then I'm fine.
It's about like throwing meat into the pit being the legislature, the lions being us. And once we get the meat, we can do what we want with it,
It's to get to me, and the meat is the inventory.
Yeah, yep.
And
So happy to be part of it.
block that metaphor.
I love this committee.
If we don't get what we think is satisfactory from the original part,
You can tweak it.
we can tweak it.
Yeah.
We see what they're presenting to us, and if we're like, wait a minute, this is not really what we want, we can go back and say, okay, can we add? Feeling I triggered you.
Well, that's what I'm worried about because I feel we've been talking about this now for a year, right? And we're talking, and we're doing a lot of talking, and we're not doing a lot of action. And I don't want it to get to another year and they're like, oh, here it is. And you're like, well, that's not what we want. And then another year has gone by. So all I'm trying to say in that trigger, you triggered me. I want it to be crystal clear.
We get an inventory.
And I think that part of what you're asking for is the report that has already been prepared, which we talked about last time.
Where it is, where did it go? The orange covers.
It's around here somewhere. It's right there. It's up. It's right next to
You want
it.
it?
Oh, okay.
You just can't see the orange.
Can't see the orange.
Do you want it, or
No.
you just ask?
No, but it's there. That's your space book. Space book.
And does that include, I'm thinking in particular of the executive order.
So that's a big old book and there's no printout yet of what's suitable for housing.
Right. And so just to be clear, the thing I'm identifying is that the executive order, which is separate from the standard BGS inventory process, right? This is a
Right.
merger of those two interests is being proposed in this bill. But if you saw the executive order report, which I don't know that you.
We did.
Oh, yeah. And you found that things were lacking there that you would have wanted to have seen. I think that would help you understand if you would be likely to get into this case.
It's just, it talks about property that's owned by the state in all the towns. But it doesn't list out the specific property. It lists the town, the total vacant square footage. But it doesn't tell you what the building is or if it's the land.
I may be being obstinate. I just want to confirm. Are you guys saying that this Facebook contains the results of the executive order report? Because I don't think,
Doesn't,
right, there's no reason that
because
it,
we should know what the property is and what the details are for it.
Doesn't.
so I'm just saying,
Top floors, everything.
identifying that information is not contained in there is,
So we
For that
have a
reason.
I would say
we
it's
have a
more
3/4 of an
Yeah.
inch document that basically says nothing.
What's that?
I said, we basically have a 3/4 of an inch document that basically says nothing. Because we don't even know what the property.
What this says is
Building looks-
owned state
What?
buildings that are owned in communities. So if you go, and I just opened it up, you've got Royalton, Rutland, St. Albans. So in Rutland, you've got the multimodal transit.
Can we sell that, please?
No, but this is what's in the inventory.
No, I know, I'm just,
But you've got the agency that it's under, Agency of Administration, and the department's BGS that has it. And then you've got occupied office space. And then you've got common area, rental area, billable area. If you go to St. Albans, you got the State Police Barracks, which is on Fisher Road. It's owned by the Department of Public Safety.
Mhm.
And you have heated occupant space of 550, which I would assume is probably square footage.
Mhm.
Occupant area total is 550,
That's as big as this.
and the common area factor is 1.39. That's what it says.
So my concern about all of this, for example, you mentioned the St. Albans Police Barracks. We live there, where Joe and I do. So I know what it is. I know what the police barracks is. I know what it looks like. I know who's there. If you mention something in Barry, Gina might know, or Connor might know what it looks like, what's there. When I read this book, it doesn't tell me what it could be used for. I would have to go there and I'd have to look. And so the information I want, I would assume is what you're looking for. I want to know, can this building be used for a purpose that you want? And I don't know necessarily if our bill is doing this or if it's requiring it. I mean, I know what it says, but I don't know. Or if the people that we're asking to do it are necessarily qualified to say, is this building good for housing? Is it good for, as we already decided we're taking out, affordable housing? But that's the answer we're trying to get to. I'm just not sure if we're,
The book isn't gonna give you
that
that.
book,
No.
that book definitely isn't. But
This book isn't gonna give you that.
so I guess all I'm saying is that whatever the finished product. on
That's
this-
why I got hung up on assessment.
Yeah, yep, that's fair.
It's not gonna tell you if any of it, it's just telling you the space that's there, how much is occupied, what's rented, what's owned. Kevin,
Theoretically, there's a report out there from the executive order. Why don't we look at the report? Why don't we ask the commissioner for the report and see if it's usable? Before we try to fix it.
is there a report out there?
Yes, yeah, the executive order report.
If there isn't, somebody needs to.
Is that available on the
you
line?
know,
I haven't seen
We got a copy of it.
are we able to get a copy?
Don't know.
I assume that you could ask for it.
Paul, do you know any of that? Because the report would be coming from BGS, right? The executive order, wasn't it BGS needed to submit it?
In consultation with PHED. I haven't seen it before. I know I flagged it for the administration. This would be.
Is that a report that's going to be on next year's deletion of reports? No one's seeing it.
exist first.
Delete it before we get it.
I understand that, but if we are talking about it.
So we need to find out. So Cole, could you go back to your folks and see if you can find out if the report even exists at this point? Or if it's still being worked on?
Other report.
Find that, and if it exists and has been submitted, we would like to see it.
Okay. We have an archive where all these reports are. The report that reported on the report that
I
then,
mean, what we did last week.
I'm just saying all the reports in state government. that are
We
never-
do have legislative reports on the legislative website, but this would be
This one.
outside that scope.
This is outside that scope
I'd like a copy.
of the report that the executive, right, well, when it gets done, Cole's gonna check to see, because you have to do it in consultation with, Housing and Community Development, right?
It was submitted to the fifth floor,
And what?
and it was submitted to the fifth floor.
You don't know if the report got submitted, do you? Did it get submitted to the fifth floor?
Yes, I just haven't seen.
Do you know when it was submitted to the fifth floor?
I'm trying to find the executive order.
It's on this,
It's
on the
required
screen.
January
Right up there.
20.
That's what, the executive order is up there?
Right there.
2025, December 1, 2025 is when it was supposed to be
Yeah, we
available.
talked about it last week.
And so
So
now,
that,
I mean, I think you could ask the question, what would the form of this report be? Like, it might be different than your classic legislative report, because this is submitting to BGS and DHCD complete inventory assessment of such and such recommendations. I don't know what form that came in. It may just be a compilation of.
But once Cole goes to the chief and asks, we'll see it in theory, and we'll know.
so could you follow up and see if, number one, if the report was submitted? And if we can get a copy of the report. Go up your chain of command. So where are we with this bill? Here, folks, I really want to get rid of this bill. Because we dealt with it last year, went over to the Senate, came back from the Senate. And it's got more steps to go. So it has to go back to the Senate.
Can we wait a day or two to see what Cole's answer is?
Mhm.
And if we can get that, actually look at it, do at least a cursory look,
But if
Is
we
it-
don't get it,
then
and
we
can't
then we
look
have to move
at it,
forward. Then we have to move forward with this bill. We probably do either way, right? But
well, it's up to the committee. This is,
Yeah, I was thinking there's benefit on carrying this beyond the immediate executive order over the next 5 years.
Right.
I think there's tremendous benefit for that.
well,
I thought the intention of this was to get it to conference and make sure that the legislature was able to show its intent as compared to the executive branch's proposal.
well, the intent is to clean up some of what the Senate
Right.
did.
Mhm.
And then the executive order has come in, and Connor mentioned that we could dovetail on that and incorporate some of the language of the executive order in the inventory. So how that plays out after that, they could accept it in the Senate as an amendment, or they could go to conference.
So my thought is wait to see if we can access the report, and then if not, move forward with it. But either way, I think we should move forward with it because that executive order, it's gonna expire at some point.
it did.
It's only for,
Well, the report is a one-time.
it's a one-time
Yes, it's one
thing.
time. We want to get this a
So
little.
we
bit
want to make
further
this
out.
year.
But we want to make it yearly for 5 years.
Mhm.
And that's what this session law is. You're changing the law, changing the green book. Want to make sure I get the right, in section 1.
Yep.
And you can see that because if you go to page 1, line 8, section 1, you're amending 29 VSA, section 165.
Yep, yep.
You're amending current law with section 1. If you go to section 2, on line 13, on page 2, there is no title.
Mhm.
And there's no section. There's only section 2. It's not amending a title, and it's not amending a section in a title in VSA. So that indicates it's session law. So you're not amending the green books.
So equally law, it's just not put into the green books because it's not a permanent direction. So
Right.
Like
Gotcha.
our capital bill is
Exactly.
session law.
Right.
We're not changing the green books.
Okay.
Okay? James,
So back to the thing, I think Will and I think I'm agreeing with what you're saying. So we want this regardless because we want it to be longer than just an executive order that's 1 year. True. And that seeing the executive order, or excuse me, the report from the executive order is more of a,
will help us with the language.
yeah, will help us with the language and also set a baseline of well, is this looking what we want, or is it not what we want, and be able to tweak the language, et cetera, because of that. So that, am I correct in my assumption? Everybody's Because I could be way off. Sometimes I hear things I don't hear. So that's what I'm-
And for my education, if the executive order wasn't executed, what then happens?
It's out of
Probably
our-
nothing.
It's out of our bailiwick. It's the executive order came from the executive
Right.
branch. Didn't come from the legislative branch, came from the executive. branch.
It is often hard to hold the decision makers accountable for the decisions that they make. Same applies to the legislature, right? You guys set rules for yourselves, but you can come back and withstand it and but it's like the conversation we had last week about whether it's reasonable to expect compliance or not. I don't think in this case, there's any reason to suppose that there wouldn't have been, and we know that there was, but yeah.
So we're back to perhaps.
I live in a world of perhaps, so I find less humor in the perhaps than you guys do. I will try to find the humor that.
Thank you.
Stone. Absolutely nothing is carved in stone.
We live in a world.
For my own, I'll wait to hear further direction from you guys, but as my takeaway for my purposes is cut the second sentence of section 2. Okay.
So let me go back to the committee. Are we, for section 1, this is changing the law. Where we are is that BGS would maintain an inventory of state-owned buildings and land. Took out leased buildings as it came over from the Senate. We also clarified that it shall be annually, not twice a year. And we didn't do anything to G, except the bottom of page, the top of page 2. This is when the head of each agency is preparing and forwarding their inventory of square footage that's used.
And state, not statutory.
And what?
State, not statutory, line 7.
Each two.
And that's kind of the big difference with the Senate proposal.
Statutory.
Right, I'm not there yet.
Oh,
Right.
I thought you were moving on.
No.
Okay.
But it's, the big change is going back to our language, unnecessary for state purposes instead of what it said for them for statutory purpose of the agency.
Mhm.
And we're doing that because,
It was unclear that there was a statutory purpose outlined in for each agency.
people are clear.
Yes.
And then they would, BGS would have to report to us in the Senate Institutions Committee on the inventory that's maintained pertaining to section E, which is the first part of section 1, page 1. That's done annually. Well, no, that's done at the beginning of each biennium.
When was it, quick question, when was the executive order dated?
September something of 25, yeah. I mean, I can jump real quick, actually.
What was
See it. September 17th was this execution of the executive order.
That about us.
It wasn't to us.
It was due in January, it was due in December.
In December 1st.
That's all internal to the executive branch.
Yeah.
It doesn't pertain to us. It's all internal to the executive.
Yeah, as far as we know, there has been no error or problem.
But we don't know if anyone has seen it that should.
So are we okay right now with section 1?
Yes.
Yes.
It's good to go.
Section 2 is the one that's really based on the executive order that we need to see what the report is to help us a little bit with this language. We have eliminated the last sentence. It starts when requested by.
Okay.
So right now, in each of the inventory, this is for a 5-year period, is our thinking.
Why just 5 years? Why
It's
not
a
into
long-
perpetuity?
It's a long time in
It is.
legislative life because people will forget it.
It gives an opportunity to review.
Got it, okay, thank you, Mary.
Well,
No,
Pretty much what Mary just said.
so we need, if we do this, we need a specific starting point. in 26?
Mhm.
Is it when the bill becomes effective?
Yes.
Is it July 1st? Because one of the bills that we passed, it was something, it was with BGS and something else. It said upon passage.
That's what I
The
have.
interpretation was, is it the date the bill passes both House and Senate? Or is it the date that the governor signs? And it was a different interpretation.
By then,
Yep. By some of the people who are.
I think those kinds of questions can be resolved, like they have answers. So, but they're not just subject to change. Yeah.
So this act shall take effect upon passage. So what does that mean in?
So when you see the acts compiled, they'll list at the bottom the date of execution by the governor, and it will say effective. If it said effective on passage, it will say date of effectiveness June 26th.
But it's when the governor signs.
Right.
It's not when the bill has passed both bodies. But there was an interpretation that was done. And it wasn't in the effective date. It was in the language of the body of this particular
Oh, it
program.
was like a strangely drafted effective date. Okay, that's not what would apply here.
Right.
This would just be when this comes into law. Yep.
It's when the governor signs.
Should we put
Because
a
it's
specific date?
Not law until the governor signs, right?
Exactly.
Should we put a specific date so
It'd be
that,
July 1st.
that's what I
But
was.
then you don't get the spring report. You get 4.
The reason this is drafted as passage is that gives you the earliest date, which you could check in. And so if it passed early enough, you pick up this year's inventorying process. You don't have to specify a date. It automatically is the date on which it's signed. Yep.
starts at March 22nd. That's what it is.
Exactly.
Then you get the spring.
Although one more dumb question. Are there not some laws that go into effect, but he just doesn't sign it?
So if
The veto.
we can override vetoes, right?
There's-
You can have that, and then you would need to specify in the act, just as we do here, what the effectiveness would be. So in that instance, on passage would be the override of the veto, right?
Okay.
But you're thinking in the right way about what is the last step. That's the thing that triggers the effective.
But sometimes, Kevin, the governor will allow something to become law without their signature.
That's what I'm referring to.
Yeah.
So that
And they're
being,
very clear that it becomes law without their signature.
Without the signature. So
It's that date.
that's an action that's
that's the
being
date
taken.
then. So that's why I asked the question. There are some occasions where that happens.
Yeah, if he writes a letter on April 15th that says, I'm gonna let this go, that's the day.
Okay. So
Right?
that's the effective passage date,
Mhm.
even though he didn't sign.
Yeah, but that decisive action was required, right? Yeah.
Well,
Believe it or not, I
So then,
understand.
maybe I'm now thinking in two different ways, but on the second page, that January 15th, that's for the inventory, but that's the annual report. So I'm confused. January 15th, what we have in the language right now, and we're
Well, I
discussing
want- but-
changing it? or-
well, that, I wondered that too, but if you look at E, Commissioner would maintain an inventory and shall annually compile and update, but they don't have to give that to us until the beginning of a biennium.
Exactly.
So they don't have to give it to us every year. It's just at
Oh,
the beginning
okay,
of
yep,
a
sorry.
biennium.
So the way to think about it is BGS would be annually receiving for this time limited duration information on whether vacant land is suitable for conversion into housing. And then at the start of each biennium, so not annually, although you could also reach out and ask for it in the same way that you can now. At the start of each biennium, the legislature would be under statute obligated to receive that from the commission. So annual flow of information, biennial receipt of information by the legislature.
One more, then I'll let you. I think I'm understanding that on line 19, when requested by, we're proposing to strike all the rest of that.
Yeah.
Mhm.
Given that, does it make sense in line 17 to say whether any property may be underutilized or may be suitable? Or are we relying on BGS to determine that it's underutilized and suitable?
You are relying on the head of the agency to make that determination.
And and that's why I'm questioning whether we want to say that or whether we want may be underutilized, because we may say it is underutilized. You've only got 25% of your people in there, and your forecast for the next 3 years is going to go up. So it is underutilized, even though you don't think it's underutilized. Who's going to make the determination that's underutilized?
The head of the agency.
Okay.
And
are
I
they
think if you,
capable?
I think,
Are they capable of determining it's suitable for conversion into housing?
I will just say that is exactly why I included the second sentence that is being proposed to be struck, is in the event that you have doubts about.
Right.
And I'm not saying it's bad to strike that. I'm just saying that language was included in case you had doubts about the heads of the agencies to determine. So you're trying to strike a balance between what is feasible to ask of each of the heads of an agency in their inventorying process and getting the information that you want. You will be reliant on their discretion. And even if you changed from is to may be, I think practically you're in the same situation. You're still reliant on the head of the agency's discretion to make that determination.
But it is broader.
It's still underutilized and suitable can mean what you want them to as well, you know, I mean, there's no, you can't stop that.
But we want the largest list possible, I think.
We have that.
Well, this section here is also based in terms of the report back on the executive order. Which we don't know what that report says. And we wanted to see what the report said so that we could look at this language through that lens. Is that correct?
Yes.
So right now, we're kind of in the dark. So, yeah.
Yeah, no, and I just want to make the point, like, once they do this once, they've got a formula for it. And as we know all the land and property that changes hands from what we acquire to what we get rid of just by virtue of sitting on this committee. What's going to differ from year to year is if a building's repurposed or if a building's raised or something. That'll differ, but it's not going to be a ton more, you know, in this report each year.
Right.
It'll just be an update.
So with that, do we still want to do 5-year process?
I do, but
Sure.
Yes, I think that's fine. Okay, so do we want to do it fiscal years or do we want to do it calendar years? So calendar year. If right now what John has is calendar year for 26. If the bill passes and gets signed before they do the spring inventory, and they do the spring inventory March and April, I'm assuming. Do you know, Cole, is it March, April?
Sounds about right.
It would have to become law before they do the spring inventory to kick in 26. If it doesn't pass before they do the spring inventory for 26, we won't get a report next year. It wouldn't kick in until the spring of 27.
we get the report. in
And
28.
when a report is.
And you get the,
Yeah, show calendar year for sure.
Mhm.
So let's just.
Calendar year.
So
but you gotta make sure it gets to be law before they do the inventory this spring.
here's another thing you could do, which will be annoying for them.
Ooh.
If it passes late and you want the information immediately, right, which would disrupt the process of the standard March, April. But if you came to the position that this isn't going to pass until sufficiently late and you want it to happen this year, but you've already passed the point at which they compiled those, you could say, and again, it would be annoying to them, but in each inventory, the head of an agency conducts pursuant to such and such statute for purposes of the annual inventory that the commissioner compiles in calendar years 26 through, right? Because the commissioner is preparing it on the basis of information received, but it's not being released until the summer. So you could say for purposes of the inventory compiled by the commissioner in summers, basically making it clear that it needs to be complied with this year, regardless of when it's passed.
So wouldn't that automatically be if you did it fiscal years?
And so that to me is still kind of a question. I agree that that would be a reasonable interpretation of it because you would say, here's the summer report, which is fiscal year 27. But if it was just the commissioner compiling the inventories that they already have, which were completed pre-change to law, then they may not have that information available. So I think the greater specificity we can give as to what needs to be done, the better.
I
Yeah.
go with what John's saying, because then it's in writing, they can't go around it.
So keep that in the back of your mind in terms of the next draft.
Yep.
So if we don't get it in 27, it means we don't get it until 29.
28.
Well,
The
from a
beginning of
biennial,
Friday.
Yeah, no, we
in
know.
terms of what the legislature is.
I don't know why I said 28 earlier, but yeah, 29 for the beginning of the biennium. Unless we ask for it, or we specify some other way in your bill. But you take care of that.
So another way, I mean, in part, you have a structure, actually, okay. I need to run to Senate Finance, but I have an idea. And one would be unlinking this session law provision, section 2, from the updates you're making to section 1 and just saying, we want reports annually. You know, in 27, 28, 29, 30.
Clean it up.
Yeah.
Clean it up to say that. That would be.
Okay.
Please walk to Senate.
So we're gonna deal with this in one way or the other. So, Cole, if you could run this up the chain of command in your world and find out about that report.
See a smile on his.
Did you find out anything at this point? Yeah, no. Okay.
It's keeping busy.
See you guys.
Thank you, Mark.
Thank you.
Thanks, John.
Well, just one last thing too, with the executive order. I pulled it up and then I know John was showing it to us, but what's interesting about it is it's in section 5 of the state land utilization, right? It says by December 1st, 2025, which was by now 2 months ago. We thought we would have gotten it, seeing that we are the committee of jurisdiction. We wouldn't have to,
No, because
No.
this is an executive order.
okay, but.
Doesn't involve the
So
legislature.
it says each state agency and department owning real property shall submit to BGS and Department of Housing and Community Development, all this stuff, right? But that's it. It goes, then what you're saying is that then the executive
Branch has that information.
and that's it. They're not sharing that with anybody. They don't have to share that. with
That's why we're pulling it into the bill.
That's
right?
right.
That's why we want it specific to us.
Because they may have the
I don't see it.
information, but they're not sharing. Unless we ask, and then we'll see if they have it, and then we'll see if it's for them to make internal decisions.
Everything all right?
That's why it's an
It's
executive
not
order.
a state government order or an executive legislation.
Thank you.
I think we should have a
Yeah.
road
Let's go.
trip to the place where we store all the reports. Because almost every single bill in this building has a
To the way
report.
government works.
And no one ever sees or looks at it.
You say that with a smile.
This is what's happening on the federal level.
I know.
This is just an
I know.
executive order on the state
Saying
level.
all these reports are gonna be released and I maybe only get 2 or 3 of them
No.
sent to me directly. I'm like, where are
Okay.
they? It's like, huh?
Oh, that's
They're not even a
right.
report designated person. who
What's
goes
coming
get
up tomorrow?
That's what I'm saying. It's constant, another report.
Yeah.
We report on the reports that we.
Why was that supposed to take that long?
Hey, yeah.
No. Well, that was good.
I don't know. Yeah. So we're gonna shift gears, folks. We're now gonna be working on page 540. And this was a working group on the reparative. Wanted to say the reparative boards.
Yeah.
There was a working group to do a report on the post-adjudication reparative program.
Yep.
And the bill is page 540. We've had with us some folks who actually served on this working group to give us their take on why they're proposing this change and to ensure that the language of the bill is reflective of the working group's report. So I don't know if we start with the judge Or we start with DOC? We start with you, Judge Zoning? Why don't?
That's fine.
No? Oh, okay.
That works.
Why don't we start with you? Give us the background of the working group and then your recommendations and why you made the recommendations.
Certainly. So good afternoon, Tom Zone, Chief Superior Judge. The legislature in Section 4 of Act 180, H 645 last year, created the working group. And the Post-Adjudication Reparative Program Working Group, a lot of words in there, we were asked to look at a number of aspects of basically reparative probation after sentencing and the use of it. The working group consisted of myself as chair, Derek Medownik from DOC as vice chair. We had Courtney Whittemore from Franklin Dial Restorative Justice Center, Neil Fabro, the executive director of the Community Restorative Justice Center in St. Johnsbury, Jeannie McLeod, the executive director of the Barry Community Justice Center, Damian Barnes, who was the program director at the time of Rutland County Community Justice Center, and Casey Viado, who was the Restorative Justice Co-Director, Interaction Youth Services and Restorative Justice down in Brattleboro. As part of our activities, we had the statute, the act telling us what we were supposed to look at. We also had the ability to seek input from stakeholders. This included reaching out to entities that were identified in the act as well as other entities. We heard from representatives of the departments of the state's attorneys and sheriffs, the Office of the Attorney General, Center for Crime Victim Services. We also had Jeannie McLeod, who I indicated was a member of the committee, of the working group. She had reached out to her CJCs, the community justice centers across the state, to serve as a liaison, essentially, to get information from them, to get feedback on what we were doing. The working group, we looked at statutes, we considered information from stakeholders, as well as information and insights from the members of the committee. We re-examined the scope of what we're supposed to do under the act. We looked at the current statutory provisions to determine which of them, if any, should be maintained. We looked to develop a consistent referral process across the state to determine what sentences or offenses should be able to be included. And we wanted to also make sure that there was any proposal provided for geographic justice and access to reparative programming across the state. And finally, one of the things that was important was that there had to be some level of discretion for the CJCs as to the cases they will accept, because it works better if the CJCs are, if you will, on board for the cases that they're getting and have a voice in that. And so the committee made a number of recommendations which were adopted into what it looks to be H 540. We were asked to come up with a report that had not only recommendations, but was essentially put it into bill form. And so we did that, and H 540 represents what we advocated as the appropriate changes to effectuate what our recommendations were. If you look at H 540, the first section, section 1, what that reflects is two goals of the working group. The first was to simplify the authority section under 13 VSA 7030 to make it consistent with other statutory sentencing options in the same statute. And also to make it clear that the referral was to a reparative program, as the term is used under Title 28. There's terms about reparative boards and programs, and they were used at different points within the statutes affecting this. And the committee concluded that it should be reparative program to be consistent. And so on page 2 of H 540, even though all those things are crossed off, and you may look at it and think, boy, there's a lot of changes, stay tuned. There's really not any. What those changes are in that section is simply to, again, simplify the reference to where you go to look for the rest of it. And so section 2, what we then did was we took the language that's being struck from up above in section 1, and we incorporated into section 2. Well, I'm sorry, section 2 is, before I get to that, section 2, we crossed off the part about civil contempt for child support because no one ever heard of that being done, and there was a consensus that there was no, that was not an appropriate use of the reparative board. Section 3 is the section where we took the language from section 1 that was taken out, and we added a section 913 in Title 28 under the reparative programs statutes where it would work better. And we came up with a, for lack of a better phrase, one-stop shopping. Here is where you go to look about how the reparative referrals are made, how it works. And so subsection A talks about the offenses that qualify. This does not change existing law. The committee's conclusion, the working group's conclusion was to maintain the existing referrals that the legislature has already had in effect. And so section A is just putting it somewhere else into section 913. On page 3, when you get to line 8, subsection B, this language is a continuation of language from section 1 that was crossed out. And it provides clarity that you don't have to be on probation to have a reparative sentence. It also talks about what happens if the cases are not completed and they can send it back. On line 14, again, subsection C, it makes it clear from what is already the current law that it can be, reparative probation can be a condition of probation. That a restorative justice program can be a condition of probation. Section D on line 16. Currently, there are no factors for courts to consider or state's attorneys or defense attorneys to consider when saying, is this offender right for a reparative referral? And the working group came up with these factors that are non-exclusive. In other words, these factors are not the only factors a court can consider, but they are factors a court should consider. And they talk about whether there's an agreement, victims' views, impact of the offense on the community, offender's willingness to participate, the offender's capacity to meaningfully participate, and whether there's any orders of protection in effect or have previously been in effect between the offender and the victim. I would point out that these specific factors each came from the insights and experiences of the CJCs and Derek's involvement with DOC about areas that if you can see issues up ahead, we would want to identify. We want to flag them so that people can look at them. If someone has no ability, whether it's transportation, whatever it may be, and they're not going to be able to do it, we want to look at that up front. If someone is not willing to do it, there are times where you may still say you're going to do this as a sentence, but there's other times where an unwillingness may lead the court and the parties, if there's a plea agreement, to say, no, this is not appropriate. And so we felt that putting these factors in provided guidance. There is currently no such provision in the law, so this is something additional, but we believe it's beneficial. Section E on line 6 of page 4 talks about standardized forms for referral of offenders to be used in all courts. And this starts taking us closer to that geographic justice and geographic access issue. We shouldn't have 14 different forms across the state when we're sending people to these programs. The consistency that we build in by having a set of forms that's going to be used statewide, the working group felt would benefit the programs and the individuals participating in them, as well as the public and the victims. And likewise, subsection F on line 9 has a provision that the Supreme Court may adopt procedural rules to effectuate this section. As you may know, we have rules of procedure in criminal court. For instance, there's rules that talk about the sentencing procedures. There's rules 32.1 that talks about violations of probation. And so that type of language makes it clear that the court may in the future decide to adopt if it feels it's necessary, the Criminal Rules Committee could adopt a rule on reparative probation referrals and to further fine tune things there. But when you look at the bill all in the final analysis, I think the view of the committee was that it's a bill that adds clarity, adds predictability, adds equal access. It has provisions that we think will make it more robust to be used. And on the positive side, guess how much the budget request would be?
Zero.
Zero. And so it's something that we think has, the committee's conclusion was that it was a benefit to basically every aspect of the system and what we're trying to accomplish. And that is, appropriate sentences, victim input to have offenders not engage in behaviors any further. And so we thought this was something that really stepped in that direction and was something that where we already have these statutes in different places, this adds clarity where we think it's needed.
I appreciate where it adds clarity, but I think also if you go to page 2, line 16, right now, the program, restorative justice program, is a condition of someone's sentence. It's a condition of their release. Right?
It may be. Currently, you can be referred under section 7030. If you look on page 2, line 6, the language that's being crossed out, referral to a community reparative board pursuant to this subdivision does not require the court to place the offender on probation. And so under current law, the referral to the reparative board or reparative program can be a standalone sentence. And what this does is it makes it clear that it can be a standalone sentence, and it's not, if you will, getting lost in the middle of a long paragraph.
So the way that the current law is written on lines 6 and 7, it's more of a referral to the reparative board, reparative program. And it doesn't require that the person be on probation. So it's a
Correct.
referral, but it's not really a sentence, is it?
It is a sentence. I
It
think
is
the
a
word
sentence
referral,
in
it
the
is a
court-
sentence.
In the court's world, it is a sentence.
Correct. For instance, so if I have an individual come before the court and the court believes, if I as a judge believe this should be a reparative probation sentence, or I can put the person on probation and then have a condition of probation under the existing law to say, in addition to all these other conditions of probation and the supervision that I think you need, you're also going to do the reparative board. That's one way. That's as a condition of probation. But if the court, if I conclude they don't need probation, we don't need to have DOC monitor them or supervise them, but instead, the completion of the reparative board itself, the reparative program, is an appropriate resolution to that case, I could impose a sentence that says your sentence is, you shall participate and successfully complete the reparative probation, the reparative board, the reparative program, and then send it over. If they don't successfully complete it, they would come back to court and the sentence is open. In other words, there can be a different sentence. And I can think of times where I would tell people, here is what's going to happen if you come back to court and don't successfully complete it. Here is what your sentence will be. So that when we came back, there was knowledge of it.
So this really clarifies in language what the practice is. So referral in the layman's term doesn't mean a sentence, but in the judicial court world, that does mean a sentence.
That's correct. We impose the sentence and we refer it over, but your point is well taken, and I think it's important that this clarity helps to make no mistake about it. It's a sentence.
Troy?
And if they're referred but are not on probation, there's no DOC supervision. Is that accurate?
That's correct.
And they make an agreement with that local community justice center in terms of what they need to abide by. And it's an agreement with the reparative program, and DOC is not involved in that.
That's correct.
Questions from the committee? Clear?
Yes.
Okay, so that's the first section. So if you go to section 3, on page 3. So we're still using that term, restorative justice program referral, even though it's a sentence, correct?
You're correct.
So in order to be sentenced to a restorative justice program or to be referred, it's one and the same. The court has some requirements. And it's that the offender has pled guilty to a non-violent felony. Could you give us some examples of what a non-violent felony might be? Just a few. Just so folks, this is in our world, so it'd be good for members to have a concept.
Financial crimes that are of a certain level that the number is higher than the misdemeanor amount.
Yeah. And
A breaking a window that has a high value.
unoccupied, or is it occupied?
Unlawful trespass thing, something that is violence is not part of it. But a lot of, I say, home improvement fraud, things like that.
And then what about a nonviolent misdemeanor?
Unlawful trespass, retail theft. Those are very common ones we see.
And then a misdemeanor that does not involve the subject area is prohibited for referral. So what subject areas, and this may be more Derek's world, what subject areas are not allowed to be referred or sentenced to our community justice centers? Is that more for you, Judge, or is it more for Derek?
I'm grabbing the book of all knowledge so I can go right to 1967.
Just so the committee has some concepts here.
No case, section 1967, no case involving domestic violence, sexual assault, or stalking shall be referred to a community justice center except through Department of Corrections offender reentry programs pursuant to protocols protecting victims, or as provided in section 1968 of this title. The Community Justice Center shall work with the Department of Corrections and the Center for Crime Victim Services or its designee to develop victim safety protocols for community justice centers that take into consideration victim needs such as safety, confidentiality, and privacy. And then section 1968 is entitled Referrals for Domestic Violence and Sexual Violence Cases. And what it talks about, it says, subsection A, it says, notwithstanding section 1967 of this title, community justice centers may accept referrals for domestic violence and sexual violence cases, provided the community justice center has a current and executed memorandum of understanding with a local member organization of the Vermont Network Against Domestic and Sexual Violence. And then it talks about the requirements there and things with the Attorney General. There's a lot of sections to that.
So there's protections in there.
It is. And again, that's the existing law. That is what has been brought forward in subsection A on page 3.
Because on page 2 for the committee that has the bill, This is lines 3 through 6. It's just being moved,
Okay.
okay? So it doesn't change current practice. It just clarifies that it's being referred or sentenced to the program, where before it was to a board, and in some places it was a board, in some places it was a program.
Correct.
Okay. Questions from the committee? Are we good?
Well, so does that mean there's no more, there's just the, I guess, are there boards now? Are we?
Yes.
Okay,
But they're
A board's part
within,
of, a board operates under the program.
okay.
and the program is through your community justice centers.
Correct.
Confusing?
A little bit.
So then if they are referred, they're not required to be on probation. That's in little b on page 3.
Correct.
And then in a sentence where the referral is not a condition of probation, because it still could be that the referral is a condition of probation, correct?
Correct.
So they can get to the reparative program as a direct sentence, or they could get to the reparative program, their sentence to probation, and the reparative program is a condition of that probation.
Correct.
Does that follow? Are folks following that?
And the CJC can deny, they can turn it down.
Can deny.
Correct.
Who can turn it down?
The reparative
Oh, yeah,
program.
yes.
So if the reparative board, which is how they carry out the restorative justice program, does not accept the case, then the offender would return to court.
Correct.
All right.
Or if they fail, the offender fails, they would go back to court.
Yes.
Okay. And then in C, the court may require participation as a condition of probation, which we already covered. And then if the offender is to participate in the program, regardless, this is regardless if it's a strict sentence or if it's a condition of probation, the court needs to look at these factors. Is that true in both cases?
Yes.
And these factors were all brought to bear and came forward from the working group.
Yes.
And was everyone on board with this
Yes.
in the working group?
Yes. I'm unaware of any individual, any member of the group who did not vote in favor of the report at the end. The report was reviewed by everyone and everyone had an opportunity to weigh in. And it's my belief, and Derek can weigh in on this, of course, that everyone on the working group felt that these were appropriate requests to the legislature.
So I have a question on page 4, line 2. How do you determine, who determines court would consider these relevant factors, which is great. You know, if there's an agreement between the parties, you would know the view of the victims and the impact of the offense in the community and the offender's willingness to participate. You would kind of know that as you go through the process. How would you know an offender's capacity to meaningfully participate, and who determines that?
It would be determined by the court in the final analysis, but it's the type of information that when a court's imposing sentence, the parties have an opportunity to bring the court information about the offender. For instance, if there were cognitive issues, if there were issues of that somebody can't do it because they have substance abuse treatment that will interfere with the ability to go to the board. Things like that they might have the willingness, it might be perfect for them, but they don't have the capacity to meaningfully do it because they're going to be in treatment for 6 months. Something like that. That's the information that the court would receive from the parties.
So if they check the box in 1 through 4, and even you see in 6 that there was no orders of protection in effect and everything was okay, could you deny the person being put to a restorative program? Just from number 5?
The factors are to be weighed, not counted. And so the sentencing judge does not have to accept an agreement of the parties if they believe that someone should go to a program. If the judge says that he or she does not concur with that based upon the judge's weighing of these factors, then they would not be sentenced to that. And so, yes, it's not a matter of, well, they have to hit all of them or they all have to weigh equally. The judge has the final say to determine what is the appropriate sentence. For instance, I would note that there could be a circumstance where all of the factors weigh in favor of going, for instance, but the victim says, I don't think that's an appropriate resolution. I think that they should have X, Y, or Z for a resolution. A judge may say, that outweighs the rest of the factors in my mind when I'm weighing out the appropriate sentence. And so the judge does have the ability to weigh the factors in a manner that that the judge may conclude they are not imposing a reparative referral as part of the sentence, or as the sentence, as the case could be.
So the only thing that is new under this language from current law in terms of the restorative justice program is the weighing of these factors.
Is to put the factors in, and also the section about the court administrator to create
Procedural
forms
rules.
and language about the Supreme Court adopting procedural rules.
Trying to
That
bring
was
the
that-
committee. I'm just trying to
sorry.
bring the committee along to understand what's in the bill.
Yeah, those last 3 sections were the only new ones, essentially.
The current practice and current law,
That's correct. That's correct.
except in weighing the factors, because you don't have
Except-
really the factors now.
There is no guidance. That's correct. I can say that it's safe. I think it's safe to say that these are the types of factors that judges should and parties should and do consider, but putting it out in the statute provides I would say, predictability and consistency across all counties and in all courts, so that everyone knows this is what we're looking at as the identified factors.
Questions from the committee? Clarity? Is it clear? Do people understand it?
Yeah, it feels almost too.
Too easy.
Yeah.
Good to be true.
Something doesn't feel right.
Gotta find something.
So that's a good
Doesn't
thing.
mean anything.
You weigh in on accountable or affordable housing like this?
I will tell you that the goal of our committee, of the group, I think was what you're seeing here, and that is, let's get something that works, that is an improvement. And it was a pleasure working with the members of the CJCs, because this was a working group where everyone shared the same goal. And we all came in, basically put it out on the table and said, here's our experience, here's where we think it's worked, here's where we think it doesn't. How has this affected you positively, negatively? And I thought it was I was really pleased and enjoyed working with the other individuals on the working group.
Novel concept.
Okay, James?
I mean, I think this is maybe obvious, but just in case, people sneak up on me. So Derek and Judge Zoney, maybe you're a doctor too. Do you both look at this bill and feel it's cool? It's the right direction? Is there things that you'd like to see different?
Certainly, well, I would say this, the determination of policies are, and how to adopt them are for the legislature.
We
The
know.
legislature has previously adopted policies for reparative programs and reparative boards, which is as put forth in certain statutes. And this bill, I believe, takes the legislative policies that you have identified and puts them into a statutory framework that is an improvement over where they previously were insofar as having clarity, predictability, and an ability to be used by the parties in a way that enhances our ability in the courts to do justice through sentencing and public safety and to provide appropriate resolutions for victims too. So again, it starts with your policies, but I think this bill effectuates your policies and has language that helps us get to there better than we currently do.
Okay, Derek? Same question.
Hang
Oh,
on here.
what do you mean?
I want to allow time for Derek to testify too.
Okay.
So let's keep that in the back of your mind, Derek, okay? Because we're going to shift to you for testimony.
Okay, for the
Okay,
record,
hang
Derek,
on. Hang on. Any other questions of the judge before we switch? Troy.
How long are you gonna keep the beard?
I'm not sure if the committee is aware, but I had knee replacement surgery several weeks ago. And it has been an external motivating factor for me to decide to say I'm going to get to a certain level of being able to move my knee for range of motion. And so when you see the beard come off, you can say he made it.
All right. You let me know when you want to get ready for competition.
We're rooting for you. So
Thank you.
Derek, we're going to shift over to you. Derek is part of DOC, works intimately with our CJCs. Derek, so if you could introduce yourself for the record and maybe start off with answering of James' question.
my pleasure. Derek Miodevnik, I'm the Community and Restorative Justice Executive with the Vermont Department of Corrections. And I'll preface my comments by saying that I think we're all familiar with the notion of a hard act to follow, which is in some ways sort of a sideways compliment. But in this case, this is an easy act to follow because I think Judge Zoney articulated in a way that I doubt I have little to add. Our process, the basis for our confidence in the product, the statutory context in which it is designed to work, the operational impact, and the fiscal impact, which appears to be nothing. So for all of those reasons, as well as the distinction between the broader policy goals of the legislature and the tasking of the reparative group, and my concurrent sense that this was consensus driven, it relied on the professional lived experience of the people doing the work as represented by 5 colleagues from the DOC funded agencies who in turn liaised with the remainder of those agencies as well as other critical partners. And I think it accomplished the task that it was charged with, and to that extent, I have full confidence in the bill for what we were charged with doing. I'm happy to answer other questions, speak to any other dimensions of it that you feel haven't been covered, but I think Judge Zoney took us through it in a really clear and definitive way. And I appreciate that.
Seems too easy. Something seems amiss.
I used to consensus.
Kevin?
So do I dare ask what you project the effect of this new law will have? Will there be many more individuals that are able to participate?
I think that's a great question. I think that what we've done here is to create an operational consistency that on a systemic level will, as Judge Zone remarked, promote geographic justice through, using the same forms, establishing consistent criteria. I can't conjecture as to how those changes may or may not, in and of themselves, and then based on all the other variables that impact, sentencing demand, I wouldn't hazard a guess as to how that might in any way correlate or correspond to projected case volume. And I also defer to Judge Zone if he has other thoughts on that. But I don't feel like I can help you on that one. My apologies.
Thank you.
I have a question, not of you, Derek, more of the judge. In terms of the Supreme Court adopting the procedural rules to carry this out, what would be the length of time to do that? It's a
Generally,
May.
Well, it's a May. I'm not really sure that there's a necessity for procedural rules to carry this out right away. I think this is one of those circumstances where it might be best to see how it starts playing out and have the Rules Committee, if we identify any areas where we may need to. If we assume that there's going to be a need for any procedural rules, I think that the process would generally be someone would suggest it to the Criminal Rules Committee. At one of its meetings, the Criminal Rules Committee takes it up. The Criminal Rules Committee decides whether or not it wishes to move forward with something, depending on what the issue is and how long it takes it up in its meetings. That could be several months. If the committee decides it wants to send something to the Supreme Court as a proposed rule, it goes to the Supreme Court. The Supreme Court would then have an opportunity to send it out for public comment. It would go out for comment generally for 90 days. After the public comment period, the Supreme Court would decide whether or not it wishes to adopt the rule. And then it would have a start date. Historically, the start date for Supreme Court rules, absent some type of emergency, is July 1, like legislative actions. And so it could be a process that takes time. And then, of course, it goes to Joint Legislative Rules Committee for review after any rules changes.
So it could be a good 6 months, 8 months process at least.
Yeah, absolutely.
Just so there's a time frame.
But the adoption of rules does not, in my view, impact the ability of the statutory benefits to start on day one of the enactment. They would fine tune it perhaps for any areas that came up if there was identified reasons for a rule, but it would not impact the ability of this to start having the benefits that I think the members of the group thought would flow from it.
Any other questions? Thoughts? Clarity? Seems too simple.
Yeah.
So what I would like to do before we take any vote on the bill, whether to vote it out or not, I'd like to have a conversation with the chair of the Judiciary Committee because it is setting up a sentence, which is beyond our jurisdiction. Justice Center's reparative program is sort of in our jurisdiction because a lot of the money comes through DOC for this program and for our community justice centers. So that's our linkage to this. And it was initiated by DOC, the reparative program, and our CJCs. So I'd like to pass this bill by them, just so that they can see if they have any flags before we actually vote the bill out. So that's what I would recommend. The committee's okay with that.
Just to clarify, so you're just gonna talk to Martin?
Yep.
One-on-one. Good.
And also to the sponsor of the bill too, as well. And if they don't have any issues, we can vote the bill out in the next few days. That's my thinking. Should be good. Anything else before we finish up and take a quick break? Thank you both. We really appreciate this.
We hope.
Thank you.
We hope
Have a great
you're
day,
on the-
everyone.
We hope
Yes.
you're on the
And
mend.
we're looking forward to the beard coming off.
Not
necessarily. I will say it, every now and then someone says it doesn't look too bad. I'm going, "Oh, maybe I'll keep it. Who knows? So
Who knows?
I
It's a
think
good look for you.
Thank you
have
both.
a great day. Take care.
Thank you.
Thank you.
Bye-bye.
Thank you all.
So let's take a quick break and be back here by 3:00. And Hillary, I have